expectancy table, and that'll be it.
And then we're going to the motions, correct?
So I want to raise an objection on the life expectancy tables based upon the Jansen motion that we filed and the improper evidence that Mr. Jansen submitted as far as that's the basis for these life expectancy tables. And so I just want to note it on the record. I know Your Honor's already ruled on it.
Note your exception.
Well, and Your Honor, secondary to that is there's absolutely no proof that this is a permanent disability that's going to be with her the rest of her life at all. And the relevancy of a life expectancy table is zero in that situation. There's no proof to support introduction of that exhibit.
Note your exceptions. Ready for the jury.
You may be seated.
Ladies and gentlemen, I'm going to read from the Statistical Abstract of the United States, volume that was published in 2011. From the Life Expectancy Tables 105. The life expectancy of a 37-year-old female is an additional 45 years. Now, Your Honor, we'd like to pass to the jury copies of Exhibit 30, the plea agreement. Your Honor, the plaintiff, Erin Andrews, rests her case.
Looks like there's extra copies there, Mr. Carville. Thank you. Well, ladies and gentlemen, jury, I'll excuse you again. We'll call you back in a few minutes. Motions.
Thank you, Your Honor. This is of several motions going to be brought asking for a directed verdict. This one premised on the superseding intervening doctrine in Tennessee. Specifically in this case, Your Honor, the proof is that all the proof in this case is that Ms. Andrews learned of this due to the uploading by Mr. Barrett, but went to see counseling because the world was seeing her image on the internet. All the proof in this is related to that. There's no proof that it arose out of a room that may have been assigned. Relative to that, though, let's assume that there is, or not that there is, but that claim was the premise of the mental injury claim that's made in this case. There's no proof that that happened. The only proof in this case is from Ms. Bonacontri, from Mr. Strachan, Ms. Rivera-Keene, and what they testified to. Ms. Bonacontri testified that the call could have been made at either location, either one of them. That call, I'm talking about to confirm whether Ms. Andrews was staying there at the hotel or not ahead of time. Secondly, Mr. Barrett then called Marriott International, made a request for the room next to Erin Andrews, that the person who took it put it in the I field, and that it didn't go down to, and would not have been read at the location in Nashville, Tennessee. That's what she testified to. Mr. Strachan testified in this particular case that the reservation reflected that there was a request for a king bed, and that it was a guaranteed request, that the room next to Ms. Andrews was a double bedroom, and that no way would Mr. Barrett have been assigned to that room next to Ms. Andrews. Third is the proof of Mr. Barrett, the testimony of Mr. Barrett. Mr. Barrett testified that he never used Ms. Andrews' name at the hotel. So if you want to begin with the premise that the hotel made this room assignment to Mr. Barrett, there is no proof of that. There's none out there at all. But secondarily to that, even if there were, the damages in this case arise out of the images on that internet. This case is like the Doe case, Your Honor, in the Lauria case. Doe, as you know, is the one where a company had keys locked into a house. An ex-employee had stolen a room. Ex-employee had stolen keys to that room, had gone into that room where the keys were stored for a development that they were building, stole the keys for the new development, and then after the new development was completed, a purchaser bought a home. This ex-employee then went over to the home, broke into the house, and raped the new buyer of the house. The court found as a matter of law that that was not foreseeable. It was an intervening superseding cause, and there was no liability on the part of the defendant. The other case is the Lauria case, Your Honor, and that involved Kmart. Kmart had guns that they stored inside a store. They were alleged, or the theory against them was that they were negligent in the way that these guns were stored there. Some people broke into the store and they stole the guns. After stealing the guns, they then went to a school, they encountered law enforcement, shot one of the law enforcement. Law enforcement then sued Kmart because of the way that they negligently stored the guns there. The court in that case also held that the acts of the criminals who stole the guns were intervening and superseding. In this case, Your Honor, what you have is Mr. Barrett, who has gone to this hotel. He's gotten this room through the way that he testified to, but he's gotten this room however you want to say he got it. What then happened was, after getting this room in September of 2008, he then held on to this video until February of 2009, and only then did he make that overt act to upload it to the internet, and he uploaded both the Blackwell video and the video from the Marriott here onto the internet, leading to the discovery by Ms. Andrews and others in July of 2009. In this case, Your Honor, is very similar in terms of the applicability of the law in Tennessee to superseding and intervening. And so on that basis, Your Honor, my clients move that this case be dismissed as to them pursuant to that superseding and intervening doctrine.
I'll now pass up to the court a document we had prepared in anticipation of their motion for a directed verdict Now, the jury can conclude that this hotel, when they put all the evidence together, did everything but give Mr. Barrett the key to her room. They can conclude they told him she was going to be there. They can take all the evidence in the light most favorable to the plaintiff. This never would have happened had they just called her and said, there's a man named Barrett who wants to be next to you. She testified, if they had just told me that, I could have alerted the police. I would have left the hotel, and this video, that whatever criminal conduct Barrett was going to do, it never would have happened at the Marriott. And that's just based on that. And there's so much evidence about the peepholes, standard of care being you have to keep it tight. Testimony about how easy it would be to look through the peephole inside a room, photograph, film, do whatever you want. And you've already addressed this superseding cause motion pre-trial. The legal issues are the same. Nothing has changed, Your Honor. But the jury could find this is 100% the law of Marriott, Nashville Marriott. If they had done right, he would not have ever posted this video.
Now, very briefly, this issue was decided once before on the basis of motion for summary judgment. This is a different standard that's now before this court. There is no proof. For example, and this is just handed to us, and I appreciate that we've had it before. And they rely upon, throughout the memorandum, again, I've only had a couple minutes to go through it. Having said that, they rely upon testimony, for example, question. And if she hears from the Nashville Marriott that there's some male who she doesn't know and has never heard of, who wants a room next to her, what do you think her reaction would have been? Shock, I suppose. That's in reference to the question before. Do you know anybody at the Nashville Marriott at any time in these events that picked up the phone and called Erin Andrews and said, you know, there's a fellow, either by computer or in person or however it happened, that says he wants the room next to you? Do you know of anybody that called to tell her that? Well, Your Honor, in this case, there is no proof that anyone at the hotel knew that. None. There is no proof of that. You've got to assume facts that simply are not in evidence at all through any of the witnesses by the plaintiff. Secondly, Mr. Kennard argued, well, the jury can take the facts most favorably for the plaintiff and find that all this occurred by negligence of the Marriott. Well, Your Honor, that gets us into the motion that we also, or that counsel filed before trial, and that is, if that's the case, then, and this proof is already in, how did 14, 12, 15 other women get videoed? How did Ms. Andrews get videoed at the Blackwell? If that's the standard, then Blackwell should be tried in this case. And this case should be dismissed, Your Honor, as a matter of law.
Okay. Thank you, Mr. Jones. The general view of David and I, we part of the plan the court over with the motion. In the end, in the streets, a lot of suppositions have been so far based on the veracity of Michael Barrett, his credibility is certainly an issue in this case. So,
Good afternoon, Your Honor. This second motion for directed verdict was also the basis of a previous motion for summary judgment. This has to do stepping back in the process of negligence back to the first step of, is there a duty of care? And as the court is aware, the crux of a duty of care has to go to foreseeability, but it's a different type of analysis than in the superseding intervening cause, proximate cause. And I know the court's aware of the cases that have addressed this. When we were before you last time on a different standard in summary judgment, we relied heavily on the case of McClung and the requirement and the strong admonition, at the very least, by the Tennessee Supreme Court that in order to show that criminal activity on a business premises, regardless of type of the business premises, requires proof of criminal activity on or in the immediate vicinity of the property. In McClung, the property at issue had a record documented at trial of 164 prior criminal incidents ranging in severity from petty to significant. In a subsequent case, the Staples case, that case too looked, what do we have on property? 284 criminal incidents ranging from petty to quite serious. So what is the countervailing case law? The countervailing case law, and the easiest case to cite, is Z-Gym versus Dollar Rental. In that case, the court looked and said, look, there's only 2 incidents of property of any criminal occurrences on this property. That's not enough to give rise to a duty of care. So what plaintiffs argued is, well, 30 years ago there was a Sixth Circuit case interpreting a Court of Appeals case that was a year earlier that created this special duty of care for hotelers. Your Honor, we would respectfully resubmit, as we did on summary judgment, that that is not the current standing of law. In McClung, in 1996, the standard was adopted. The only reported case that either side has been able to point the court to that interprets McClung and the duty in the context of a hotel is Patterson-Corey versus Wilson World, which coincidingly, Mr. Delmarva, plaintiff's expert, was involved in. And in that case, he did the analysis under McClung, found that there was not any sufficient criminal conduct on or in the immediate vicinity of the property, and actually testified for the hotel. Now, as we'll get to in a second, Mr. Delmarva has done none of that analysis in this case. The important point is, in Patterson, they cited not to Scottish Inns, they cited not to Zhang, but they cited back to McClung. And the primary issue on appeal in that case was how far outside the bounds of the property could the plaintiff go to try to show criminal incidents to create a reasonable risk of harm. And what the court there said is a strict interpretation of immediate vicinity. It's not a property 3 miles away. It's not a property a mile away. In some of the later cases, it's not even something you can't see from the very area. That's the Keaton case. If you can't see the trailer park from the Walmart parking lot, then you can't consider the trailer park in determining the reasonable care or duty of care owed by Walmart in that case. So what does Kavargas and Zhang really indicate? One, it's a 30-year-old line of cases that haven't been cited since then. And two, Your Honor, respectfully, we would assert that Kavargas simply got it wrong. Kavargas was interpreting Zhang. Zhang said, not a special duty, a special relationship. It was commenting on the current state of Tennessee law at that time, which was cornpros, which is a very strict non-liability interpretation. And so what the court in Zhang found was, well, we feel that rule is too strict. But we recognize in the common law that there was a special relationship between innkeepers and guests, common couriers and passengers. So we're going to determine that because of that special relationship, that cornpros is limited and doesn't apply in this factual situation. So what happens the next year? The Sixth Circuit, looking back to Tennessee law, they just got the word wrong. Instead of special relationship, they now call it a special duty. They entirely skip the duty of care argument, later set forth in Doe, set forth in McClung, in every case that's come thereafter, regardless of the type of business. They simply said, well, it's a special relationship, and it's special, but the duty of care is ordinary care. So what would a reasonable person do? Well, there's nothing special about ordinary. It's ordinary care under the circumstances. So, what the court, I know, has indicated that it is following Scottish Inns. And so let's look at what the proof is so far in this case at the close of plaintiff's proof to support that. First of all, going back to McClung, there's absolutely no evidence entered in the record of any criminal incidents of significant character on or in the immediate vicinity of the property. The only thing that plaintiffs can point to is Mr. Mazaluskis indicating that a homeless person trespassed on the property once, not inside the property, but on the property, that there was a bank robber who came in through a door and tried to flush money down the restroom toilet. No indication that the robbery was on the property. It was simply likely the first place you saw an open door. And the last one that I'm sure counsel will stand up and talk about is a line of question that came out of Ms. Nina Rivera-Keene. Well, there were domestic incidents there. On further refreshment of her recollection by her deposition, she said, well, I remember hearing stuff, but I don't know any of the details. I don't know when they occurred. I don't know where they occurred. I don't know the circumstances of them. Frankly, Your Honor, a domestic dispute between a husband and wife, which could have occurred in a hotel room, it could have occurred in a bar, it could have occurred outside as they were getting in their car, has no relevance to the determination of whether a third party would commit a crime on the property. What counsel did not have Ms. Rivera-Keene testify to, but we got in on direct, is the remaining portion of her deposition testimony, that couple of sentences after that, where she says, in those instances, we had it responded to by security and police. So, an additional point, if we're still moving on before McClung, is, well, what does Mr. Delmarva say about the foreseeability of what occurred here? Well, in our very short cross of Mr. Delmarva, he affirmed on 2 occasions he had never heard of it before. Now, counsel has given us what they anticipated some arguments in response to our foreseeable motion for directed verdict. And interestingly, Your Honor, I had already briefed these same points that they've raised up. So let's go through them one by one. Mr. Delmarva says that had there been 2 security guards present during the day, this would have been, in his words, a safe and secure environment. Well, what does the proof show about what was present on the guest floors each and every day that this hotel operated? We had housekeepers from 8 a.m. to 4:30 in the afternoon. Ms. Andrews, by her testimony, has placed the window of time that Mr. Barrett must have done this between 3 and 3:30. When we had housekeepers on the floor, housekeepers that were trained and had a practice that if they heard a noise indicating that something was going on in the hall, they would check it out. They were proactive, especially on concierge floors, because they wanted to turn these rooms over. So if a guest was in the hallway and they heard it, a housekeeper would come out and say, hey, are you checking out? That's eyes on the floor. We had maintenance people that were doing preventative maintenance on a random basis each and every day. We had floor supervisors, as Mr. Strachan talked about, who walked the floors to check the rooms behind housekeeping. We had room service individuals on the floor. We had supervisors on the floor. We had people on those floors from 8 in the morning till 4:30 at night, the exact period of time that we're talking about. Now, what the plaintiff said, well, we put forth Mr. Mazaluski's testimony that we needed an extra security guard there on a night shift. We needed 2 security guards. We needed security cameras. I'll get to cameras in a second, but let's talk about the guards. What is Mr. Mazaluskis, the only proof that's been put forward of some indication of additional security? He's talking about the night shift. That's all Cumberland ever did. Another guard on the night shift does nothing and has no relevance to an event that occurs at 3 o'clock to 3:30 in the afternoon. The only proof is that there are eyes on that floor at that time who are trained not only for non-suspicious events, guests checking out, hey, are you checking out? Let me get your room. How was your stay? But also trained that if they saw something suspicious, to get in a room, lock the door, call security. These are individuals who are serving every form and function of a security guard, but they are many, many, many times over in number than two people walking 11 floors. Two people can only be in two places at the same time. We have a multitude of people that are on every floor for this exact period of time. There's no substance to Mr. Delmarva's testimony regarding two guards. So we move on. Cameras. Mr. Delmarva says that it's industry standard to have cameras. Apart from saying it, he's laid no foundation for where he's got that. He's cited to no neighboring properties that have cameras. He's cited to no property in the United States that has cameras. He merely says they should have had cameras. Other than his own statement, his ipsa dixit, there's nothing to that substance. What's more important, though, is what did Mr. Barrett say? Mr. Barrett had been to properties before, had done this before. What was his testimony? His testimony was, were you aware if there were cameras? He didn't care. He said, no, I don't know. It didn't matter to him. Mr. Delmarva's testimony is cameras are a deterrent. Well, they're only a deterrent to individuals that are deterred by cameras being present. Mr. Barrett, by his actions, clearly was not. The presence of cameras in this case would have in no way deterred Mr. Barrett. They do not form a foreseeable risk of harm. So Mr. Delmarva proceeds. Let's talk about training. And he says, well, there needed to be training on how to handle an adjoining connecting room. So let's tackle that one and then we'll get to the second one. He says that you shouldn't, and the citation is to the Sally Johnson, our good friend Sally Johnson, and the example that Mr. Kennard had Mr. Strachan testify to, which was an incomplete hypothetical, wasn't tied to any facts in this case. But what was the testimony for the individuals that actually checked guests in? Mrs. Nina Rivera-Keene said that the policy at the front desk in 2008 was that if an individual checked in, had a reservation that said, I would like to be connected to Sally Johnson, if Miss Johnson had not checked in yet, you would check that first individual in. When Miss Johnson showed up, you would then verify whether her reservation had a similar request to Mr. Johnson, or whoever that first guest was, and if so, they got the rooms to the extent they could be accommodated. If they didn't, Miss Johnson checking in second did not have an indication of a connecting room, what would be done? Well, the only proof in their record at this point is that Miss Nina Rivera-Keene, the supervisor, checked people in herself, trained people how to check in, would call that individual, in this case Miss Johnson, and say, hey, I have Jane Doe, John Doe here that is checked in, and they say they want to connect with you. That's fine. Front desk connects them. I don't know John Doe or Jane Doe. Front desk doesn't connect them. Exactly what Ms. Andrews claims should have happened here is what the proof indicates the policy, procedure, and practice in place in 2008 was at the National Marriott. So what's the second aspect of training? Disclosure of room numbers. Your Honor, Mr. Devin hit it in his argument. There's no evidence whatsoever that any person disclosed Miss Andrews' room number to Mr. Barrett. Mr. Barrett said he never mentioned a name. Plaintiffs haven't put forth any proof to indicate that someone mentioned a name. But more important, we're talking about training. What did the witnesses testify? Mr. Strachan, Mrs. Rivera-Keene, both indicated that they were trained not to give out a room number. Ms. Rivera-Keene went through the exact processes that they go through in checkout to ensure that a room number isn't even inadvertently communicating, writing the number on the inside of the key slip, folding it over, not announcing it out loud. Again, Mr. DeMarva, the only proof that plaintiffs have put forth at this point, makes a statement, but there's no proof to support it. Which brings us to the next, securing peepholes. Mr. Kennard hit it in the first one, that they had to secure peepholes. There's no proof that the peepholes weren't secured. Mr. Davenport, the only individual who's provided testimony about securing peepholes, testified about the checklist, testified that they used the checklist, and testified that as part of his maintenance, training, implementation, practice of the engineering department, those peepholes were secured. There's no evidence in the record at the close of plaintiff's proof that indicates, one, that those were not done, or two, that the peephole was somehow insecure at the time that Mr. Barrett got to the room. Now, what counsel wants to do is say, well, you haven't produced the record. Mr. Davenport hasn't been with the property since 2010, so asking him, did you ever find a record, is kind of flat. There's nothing there. This lawsuit wasn't filed in 2010. So asking Mr. Davenport whether he found a record, when he already wasn't there when this lawsuit was back in play in 2011, doesn't change the fact that his testimony was they did it. One final point. And this has to do with confirming the reservation at the Nashville Marriott. Your Honor, and I won't belabor this because I know Mr. Dedman already hit it, there's no proof that the confirmation of the reservation occurred by a front desk agent at the hotel. All of the evidence in this record is that those calls, inquiries about reservations, were transferred to the Nashville Marriott call center. There's simply an absence of record, an absence of evidence in the record to indicate that that confirmation occurred because of some act of a Marriott Nashville at Vanderbilt employee. Thank you.
Your Honor, that's a great lawyer, and he's arguing facts that are for the jury and their conclusions to be drawn from the facts. And if you want me to, I'll address everything he said, but I think you can overrule the motion and just the question of fact, but I'll be happy to argue it if you want me to. I'll go ahead and make some arguments. First, these cases he cited to you are parking lot cases. We've gone over this in the motion for summary judgment. What happens in a parking lot is different from what happens in your home away from home. And to suggest that nothing had ever happened in this hotel when we know there was domestic violence, and to say that's not serious, that domestic violence is not serious, is an offense. That's just wrong. If this place is so perfectly safe, why do they have locks on the doors? Why do they have latches on the doors? It's foreseeable that somebody can hurt somebody in a room. The peepholes are there for a reason. They have to be tight. Mr. Delmarva testified they were not tight. Where's the checklist, he said? He said Barrett, all he had to do is unscrew that thing. And he got it. And he could do anything he wanted to looking through that peephole. And he said, I asked him, how would you build a perfect storm to be sure this would happen? And he said, everything. I'd do everything they did. I'd have no security for deterrence. I'd have no security cameras on the floor for deterrence. I'd let the peepholes get loose. I wouldn't check them. Just, it goes on and on. And on deterrence, to suggest that a housekeeper is a well-trained security guard, with all due respect, and I great opponent. That's a fact argument And I hope we don't have to rely on housekeepers when we're in hotels to guard our security, Your Honor. I just hope that's not the case. That's going to be requiring too much of them, and it isn't going to do anybody any good. So I think the motion needs to be overruled. Thank you.
Your Honor, 2 points. One is if there was a lack of security, where's the record indicating that there was a lack of security? We had a third party come in and test this hotel merely months before Miss Andrews' stay. What did that test show? It showed 100%. We knocked it out of the park. 39 out of 39 on security by Marriott International, which the proof indicates is the gold standard in the hotel industry. Now, that's the only proof of an actual security assessment of this property. Mr. Delmarva didn't do a security assessment. He doesn't even know what's going on in and around the property. All he's done is find what he claims are omissions and then somehow said that those are industry standards without any citation to any actual fact, any example, any exemplar property, whether it's the Holiday Inn across the street, the Lowe's Vanderbilt up the way, or the brand new Omni, somewhere in Buckhead, somewhere in Maui. There's nothing to support his indication that these are industry standards. And with all due respect to Mr. Kennard, the aspects of a security guard are not in the record. Mr. Delmarva didn't say, you need a security guard, and here's their qualifications. Here's their certifications by the state of Tennessee. Here's all the training they need to do. They need to have this on their belt. They need to have that on their belt. They need to know how to do this, that, and the other. Nothing. What he talked about is 2 individuals that you could employ for a day for what I think he said will cost $200. Basically what he wants is 4 shoes walking the floor with the title security guard. No qualifications of a security guard. We've got that. We don't have 4 feet. We have hundreds of feet. Every day during the exact period of time that this incident occurred, trained to look for this very incident. The evidence lacks sufficiency to create a foreseeable risk of harm, and we would move for a directed verdict.
This issue, the court also arose, considering the evidence and the strong legitimate view of the plaintiff. Your case rests upon the believability again of Michael Barrett. And then the question of the precipitating event, as is in every story, there is a precipitating event, is how do you get in that room next door? You believe him, the jury may not believe him. I think it's a jury question. His credibility certainly in question in this court. As far as the security at the hotel, there was no security when this happened. The fact that maybe the policy of Marriott International made an inspection or an industry doesn't make it non-negligent. The fact that there were no cameras in the hallways or elevators, something the jury considers part of a puzzle. And as far as vehicle maintenance, that's in front of the jury too. So, this really boils down to whether the court is bound by direct evidence. It's a fact the jury can infer circumstantially anything they want to. So they promise to believe or not believe witnesses. So,
Your Honor, the next motion has to do with the damages. In this case, Ms. Andrews is suing under a claim of negligence for emotional distress. I'm not going to argue long here. Don't infer from that that this isn't a strong motion. I think this is a very strong motion that can be done very succinctly. I'll wait until opposing counsel attempts to do its rebuttal. Very briefly, in order in Tennessee, under Tennessee law, in fact your jury charge says this, in order to establish a claim for negligent infliction of emotional distress, a plaintiff must first establish negligence on the part of the defendant in addition to submitting expert proof establishing that plaintiff's emotional distress was serious or severe. In this case, Your Honor, there is no such expert other than the IT expert. That is it. Now, the IT expert. IT, information technology. Yes. Other than information technology expert, there isn't one, Your Honor. Now, if our standard here is that an IT expert can come in and prove that, then I've never seen that before. You say, well, what about Ms. Comstock? Two things on that. Ms. Comstock was a certified social worker. She also wasn't an expert. She was never tendered as an expert. She was a treater social worker. In Tennessee, a treating physician should be treated as an ordinary witness when not disclosed and not as an expert witness subject to disclosure requirements of Rule 26. That's the law in Tennessee, Your Honor. There is no expert proof of serious or severe emotional distress in this case.
Now, there's scientific evidence in the case from Ms. Comstock of a serious emotional injury, adjustment disorder like post-traumatic stress disorder. She said it's very serious. Ms. Andrews has testified about the problems that she has, and they keep calling Ms. Comstock a social worker. That was her undergraduate degree. She got a lot more training after that. And she's authorized and licensed by the state of New York to make mental health diagnoses, and she used the proper manual to come up with her diagnosis. And it's a serious mental, emotional problem. She hasn't been destroyed by it. She can still work, but you've heard the proof that it's serious. And all the law requires is some bona fide scientific proof. And there you have it. Thank you.
Your Honor, good. Again, and to be very clear on this, I am not denigrating at all what Ms. Comstock has accomplished. But that is her title. That's what she testified to. So again, she's worked very hard for that, and I respect that. However, she is not an expert. She's a treater. And the law is very clear to Alessio that a treating physician is not an expert. You cannot prove a claim for severe mental injury without expert proof. There is no expert in this case other than the IT expert. That claim has to be dismissed, Your Honor.
It's funny that you mentioned Alicia because that's the case I have. In addition to that, the Amos case and the Flash case, two leading cases on this very point. And in short, the court wrote that she may be a treating professional, not a physician, but her testimony qualified as she knew the diagnosis under DSM number 4, and the court accepted her as a person of knowledge. She didn't have to be an expert in the sense of Rule 26. That's what the court was about. But she's a professional, and I accept her testimony has been to get past that requirement in Tennessee. Next.
Apologize. Your Honor, this is tangentially related to what my first argument was, and so because of that, Your Honor, probably familiar with most of the attorneys on this, I tend to be long-winded, so I'm going to try to cut this as quickly as possible as I can. It's a motion to strike Mr. Delmarva for CSX grounds. Now that proof has concluded, each of the opinions that I addressed earlier, the 2 security guards, the cameras, the training, the peephole, They simply lack any foundational basis. His opinions as to the standards of care lack intellectual rigor. If you go to the non-exhaustive Daubert, I know my co-counsel likes to say Daubert, but Daubert principles, and we look, has it been tested and the methodology used tested? He's provided no indication of what methodology whatsoever he used, other than to come in, make blanket statements, and have no real substance. It's an empty shell. Each of his opinions are an empty shell. Has it been subject to a peer review or publication? Absolutely no evidence of that whatsoever. Is there a potential rate of error known? No. Has it been conducted independent of litigation? Absolutely not in this case. There is simply a lack of reliability and trustworthiness in the methodology utilized by Mr. Delmarva here for each of the opinions rendered. And that's based on what his testimony was here at trial. I'm not talking about what he testified in his deposition, not talking about what he might have put in an expert report. What he's testified here in court before this jury lacks any substance to support the opinions that he's made, and under CSX, we would ask that he be stricken.
Your Honor, Fred Delmarva was one of the best experts I've ever seen. A lifetime of experience, no college education, high school grad who started out as a dishwasher at the age of 14, worked his way up and slugged his way up, talking about security, getting hired as a consultant to hotels. And if I owned a hotel, I'd be proud for him to come in and be my security man. After hearing his testimony, he is so trustworthy, and the things he says make common sense. And it's a reasonable person standard. What would a reasonable person have done? And common sense runs throughout this whole case. And even Mr. Stranch admitted to 5 or 6 standards, any one of which the jury could find. If that one right there was violated, Erin Andrews deserves to win. So Mr. Delmarva was right on. He and Mr. Stranch agreed with so many things.
Your Honor, and I'll be very brief again, which I know is a relative term. Standards. I would ask all counsel in this court review what the transcript actually said. Mr. Kennard said standard. Mr. Strachan said, I'll agree with that statement. Mr. Strachan wasn't providing standards of care in the hotel industry. He was agreeing with platitudes offered by Mr. Kennard. Now, I understand Mr. Kennard vouches for the trustworthiness of Mr. Delmarva. But again, that's missing the point of what CSX requires. CSX doesn't require a stamp of approval from someone who says, I know this person, they're very trustworthy. What it requires is a focus not on the person, on the methodology. You can have Einstein here talking about quantum physics in a case, but if you can't show his work, it creates a CSX problem. That's the standard. It's the gatekeeping function. Because without that gatekeeping function, anybody with a good pedigree can come in and say anything. It's what was the methodology employed. The proof is a lack of proof. There is no evidence of his methodology. There is no evidence of a security assessment. There is no evidence of any specific facts he took into consideration other than saying, well, this is what I think should have happened. That's all we've got. That does not satisfy CSX. I don't care whether his CV is 200 pages long. If he doesn't have a methodology that is trustworthy and based on reliable facts relied upon in his scientific field, he never gets past the gate. So we would ask, Your Honor, again, that he be stricken from the school.
Okay, the court overrode that motion also. It is a question for the jury to give whatever the weight they want to. He does pass the gatekeeping process. He does have a 702 information to the jury, and I'll overrule it this time. Next motion.
That's it, Your Honor. That's it, Your Honor.
We're ready to go, Your Honor. I mean, we have no motions.
If we can take a brief recess, make sure our videos are all lined up and ready to go. Thank you.